Hello there, and welcome to this AAA Quick Take, yet another one on mandatory vaccinations. My name is Scott Moore. I'm the AAA's HR and Operations Consultant and the owner of Moore EMS Consulting. So I know that back on May 10th, Ben Wasman, the Workforce Committee Chair, and I did a quick take on COVID vaccinations and some of the other COVID-19 workplace restrictions. And then just 8 days ago on August 5th, I did a quick take on mandatory vaccinations as, of course, more and more workplaces are requiring vaccinations. So one of the reasons I thought we should tackle this again today was, one, I've been getting tons and tons of member questions, but number two, OSHA released updated guidance today that essentially says, sort of due to the incredibly or the rapidly expanding infection rate in this country, they are now suggesting essentially, or they released guidance on mitigating and preventing the spread of COVID-19 in the workplace. They're now really suggesting that both vaccinated and unvaccinated individuals, that we go back to a masking while in the workplace. There are some other things in there. It was, I think, a 5 or 7 page OSHA guidance on this issue for mitigating and preventing the spread. But certainly keep an eye out for the member advisory that should be getting sent out later today or tomorrow. So last time we talked on August 4th, 8 days ago, this top map, roughly 165 million had been fully vaccinated. Another 192 million have received at least one dose. As of today, 167, almost 167.5 million are fully vaccinated, and nearly 200 million, so 196 million have received at least one shot. Although, despite this, so the last time I did a quick take 8 days ago, top one was the map. What you could see, the yellow being the lower infection areas around this country, and red being the higher levels of infection or the higher incidence of infection. Today, or sadly, unfortunately, all of the yellow areas are gone from the map. It is all just substantial risk of infection and or high risks of infection. So when you take a look at the vaccination map as compared to today's infection rate map, what you do notice is essentially there is still a lower level of infection in areas, or the very few areas. So there are 43 states now are considered high risk of COVID-19 infection, and 7 states are at still a substantial risk. But in most instances, as you can see, there is in fact a relationship between vaccination and infection rates. Now, when you take a look at the vaccinations as compared to the individuals or the incidence of death caused by COVID-19, as you can see, anywhere on the left side where there's a dark blue area, you can see a corresponding lower level of fatality as a result of COVID-19. So the last time we talked, you've seen this slide before, although it's got some new information on there. Just yesterday, President Biden announced that he was going to expand the vaccine mandate now to all HHS employees and all VA employees. So I think we are moving in a direction towards what it appears to be a mandatory vaccination requirement for at least those involved in health and human services and or healthcare. Massachusetts is requiring that all long-term care facility employees be vaccinated by this fall. And so we're just moving. This is a continuing wave of mandatory vaccinations. So last time people asked, can an employer mandate vaccination? That has universally been ruled that yes, an employer can, provided, of course, that it's job-related and consistent with business necessity. Now, there are 2 instances or 2 groups of people who might not have to get vaccinated, and those would be those who have an ADA-recognized medical condition for whom the COVID vaccine would potentially be hazardous for them. So not just anyone with an ADA medical condition, it's anyone with a medical condition for which getting the vaccination would be hazardous. Or number 2, individuals who have a religious accommodation or who are requesting a religious accommodation as a result of a sincerely held religious belief. Now, in those instances, an employer is required to provide an accommodation provided it does not cause an undue hardship. Now, there are 2 levels of that. For a medical, an undue hardship, or to establish an undue hardship for a medical condition, that is a pretty high bar. In other words, an undue hardship is one that involves great expense or great difficulty. Now, for religion, an employer can establish an undue hardship by a far lower bar, and that is if it involves more than just a de minimis cost to the organization. In both instances, an employer is required to go through what's called the interactive process. And in some states, the interactive process must be documented. It's a good practice to do that, and I've said that a million times before, so I won't beat that up. And what is that? Really, it's an interactive consultative dialogue with you and that employee who's requesting the accommodation, or for whom you believe needs an accommodation, where you go through and analyze the essential functions of the job to identify potential accommodations, and then determine if those accommodations will be an effective job change or modification or rule change that would then allow that person to perform the essential functions of the job. So again, if it turns out that there isn't a modification, it would create an undue hardship, well, then you were not obligated to, to provide that accommodation. Now, this week I've gotten lit up with a whole bunch of questions relative to accommodation requests. So how do you manage those accommodation requests? Well, last year, I think I've said this in the last one as well. Last year with the HR manual, we put out multiple forms. So one for a religious accommodation, one for a medical ADA recognized medical accommodation, and then a reasonable accommodation process form. Right? I like forms or checklists because it ensures, number one, that you tend to be very consistent. One, when you give a person a form to complete requesting either a religious or medical, you are consistent in the way that you're doing that, and you're asking them to just articulate what it is that they're looking for and why. Now, the process form ensures that you as an organization have a consistent process for managing these. So you need to be consistent, because when you're inconsistent, that's where you put both, one, the employee at a disadvantage, but then number two, you open up the organization to significant legal risk. Now, you must be consistent, as I've said. I think I've said that maybe a lot, sorry. But you also should be confidential. You want to be sure that you are not, the information contained on these forms do not end up as sort of general knowledge amongst the organization. It should not be any more than is necessary for you to evaluate that accommodation request. Important that you know that even if someone doesn't come to you making that request, if you or your supervisors or anyone in leadership believes someone may need an accommodation, you should engage those folks and have them reach out to HR. So for a medical accommodation, an employer, in order to go through that interactive process, you are going to need some information about what is that medical condition the person is seeking the accommodation for. So, you may request information, but you can only request information specific to that medical condition, and no more than is necessary to understand the nature of the disability and the individual's need for a reasonable accommodation. So you can send the person or their healthcare provider a set of questions, very limited, but a list of questions for that healthcare provider or the individual to answer that essentially says, look, what's the nature of that illness that for which you're requesting accommodation, and what type of accommodations, or to the healthcare provider, is the requested accommodation one that will help that person perform the essential functions of the job. I always say it's a good idea to send along also a copy of the job description, because that lists the essential functions. So if in fact, when you get that information back, there's information on there that you're not sure what it means, you can reach out to the organizational occupational healthcare provider. But again, make sure that it's confidential, and that healthcare provider can help you evaluate that information. Now, when it comes to religious accommodations or an objection to the vaccination on the basis of religion, this is based upon a sincerely held religious belief, and that is interpreted pretty broadly by the EEOC. So generally speaking, an employer needs to take that employee's religious belief on its face unless they have some objective basis for questioning either the religious nature or the sincerity of the particular belief. So, in other words, an example of this might be an individual who's asserting that vaccinations are, that they object to vaccinations on the basis of their sincerely held religious belief, and vaccinations as a whole. This is one of those instances where you might say, well, what's the basis? Is it, in some instances, folks object because some vaccinations do use two specific human fetal cell lines. And now, while those cell lines were from terminated pregnancies back in the 60s and 70s, they've been replicated many, many, many times. And so as a result, some folks are asserting that it's because of the nature of the terminated pregnancies that objects with their religious belief. Now, in this instance, if an employee has received a different kind of vaccination, then that might be something that leads you to believe that maybe their stated belief is not, in fact, actually the real reason. We do know that a lot of people are objecting to the vaccination, not based on a religious issue and not based on a medical concern, but more a political objection. And that, by the way, is not necessarily a protected category. So what I would suggest for you, and this is really, you need to go through that interactive process with that employee, because in fact, no churches that I'm aware of, and I've done research for this for a long time, are objecting to or oppose vaccinations as a whole. And it's my understanding that in fact, most churches have come out and said vaccination is important, and it's important, and even in some instances seen as an act of charity for protecting those who might not otherwise be able to get it because of an illness. So again, in order to determine whether there's an undue hardship, right, the employer only has to demonstrate that it involves more than a de minimis cost. So it could be direct costs. In other words, persons requesting to maybe, not, have a second person on the truck that when they encounter someone with COVID, that person doesn't work. That's actually a fair amount of money and probably wouldn't be a reasonable request. Or it could be indirect costs, something like lost efficiencies. You can't send that person into some nursing homes. Why? Because they are refusing to let any unvaccinated people into the nursing home. And so as a result, you have to move trucks around and spend a lot of time juggling trucks, or infringes upon the rights of other employees or benefits for other employees or for patients, or otherwise impairs workplace safety or causes other workers to carry the accommodated employee's workload. So in any event, it is a case-by-case analysis. So what could potential accommodations be? Well, finding alternative vaccination manufacturers. In some instances, there are some vaccinations that have been identified by certain religious faiths as being problematic, or but for certain medical conditions based upon the way they were manufactured. You could potentially, if in fact this is reasonable for you, require any unvaccinated employee to be masked in the workplace. As we talked about earlier, basically the CDC is saying everyone should be masked now. But in addition to that, you could require physical distance. And for those unvaccinated folks, you could require either weekly or twice weekly testing for COVID-19, in addition to masking. And if it's an employee who's not a frontline employee, maybe an administrative employee, maybe that person could telework. So with that, in every instance, it is a case-by-case analysis. And if you aren't able to get through that process pretty consistently and come to yes with that employee, either yes, they're going to get vaccinated, or yes, you've come up with a reasonable accommodation, or you've hit sort of an impasse, you really should probably seek some legal counsel, legal advice from an attorney licensed in your area. So with that, I'm going to try and be very uncharacteristically briefer than usual. If you have questions, email info@ambulance.org. You can also email me directly, smore@moreemsconsulting.com. This is a tough issue. It is going to continue to get more difficult. So my hopes are that some of these quick takes are helpful for you as you work through this. If you have ideas for other quick takes, I also ask that you email the email address on the screen or me directly, smore@moreemsconsulting.com. And certainly those questions we'll tackle as well. So with that, I leave it to you, and I hope that you have a good day.